SJC-12239, Commonwealth v. Jonathan Villagran.
Mr. Zandrowski, good morning.
Good morning.
We promise to use no sports metaphors during the course of this argument.
Thank you, Your Honor. May it please the Court, my name is Matthew Zandrowski, and I represent the appellant, Mr. Jonathan Villagran. This appeal concerns two issues: whether the trial court erred when it denied Mr. Villagran's motion to suppress evidence stemming from a pat frisk at Milton High School, and two, the sufficiency of the evidence to sustain his conviction for willfully disturbing a school or public assembly. On the first issue, the trial court should have allowed the motion to suppress because there was no reasonable suspicion of criminal activity, that the odor of marijuana was not enough, nor was there any reasonable suspicion of that Mr. Villagran was armed and dangerous. The only evidence relevant to the pat frisk, supported by the record in this case, are Sergeant Murphy's observations of the school, the principals, and Mr. Villagran. Only Sergeant Murphy and Detective Perez testified at the motion to suppress hearing. And Detective Perez arrived at the school after the pat frisk.
Can I just ask, I know there was an issue about the findings of the judge versus the evidence at the motion to suppress hearing, and I wasn't sure if there was an agreement between the parties on what actually happened, and I couldn't tell. I know that he made a statement, and I couldn't tell whether it was during the pat frisk or before the pat frisk. I lied, I'm sorry.
Yes, I lied, I'm sorry. I believe that is at issue.
Okay.
I argue that that statement occurred after the pat frisk began, as well as the Sergeant Murphy at that point had also, or the Commonwealth argued that Sergeant Murphy detected the odor of alcohol.
Would you say that it mattered one way or the other? Say it happened before the pat frisk. Would that factor into whether or not there was reasonable suspicion or that he was armed and dangerous?
I would say it matters. I think it would add to the reasonable suspicion if it happened before.
Okay.
So how do we determine that?
Oh, excuse me?
So how do we determine that?
If you look at Sergeant Murphy's testimony, I believe it clearly shows that she began to pat frisk Mr. Villagran, and then Mr. Villagran stated, I lied, and she only detected the odor of alcohol after she began to pat frisk him.
So based on her chronology of events?
Yes.
She already detected a strong smell of marijuana before she pat frisked him.
Yes, that is correct.
Okay, and she'd already had some observations of the defendant outside of the school or only inside the conference room?
She responded to a call for an unwanted male party, so she had no observations of Mr. Villagran prior to her arrival at campus when she was led into the conference room.
So she didn't see him at all before the conference room?
No, she did not.
So
Okay.
so she knew before the frisk that he had tried to enter the high school and was told he could not, correct?
I respectfully disagree. I don't believe she was told that he could not enter the high school.
She was met by the vice principal when she arrived, right? And the vice principal told the police officer that there was someone who was later identified as the defendant who was trying to enter the school and that he was now in the conference room with the principal, right? She was told those things.
Yes.
So she knew that before she went into the conference room.
Yes.
All right. And so then she went into the conference room and then she smelled marijuana.
That is correct.
And then she heard the principal say to her, something's wrong, something's not right with this kid, something's not right, he has something on him, I know he has something on him. She was told that before she pat frisked him.
Yes.
Okay. So, and she had had dealings with both the vice principal and the principal before that.
Yes.
So she had some ability to assess whether their demeanor and so forth was different now than it had been on other occasions when she'd seen them.
Yes.
Okay. And did she see the defendant sweating and shaking his legs before she pat frisked him?
Yeah, she had observed that he was nervous and that he was, I don't believe she observed him patting his legs. I believe she testified that he was sweating and shaking.
So this was all before she frisked him?
Yes, when she entered the conference room, she observed that.
Okay, and so the question is whether or not she heard him say, "I lied, I'm sorry, I lied," before she frisked him.
Yes, I argue that she...
And you say we go to the testimony of the police officer and that will all be cleared up for us?
Yes, she is the only person who testified at the motion to suppress hearing who has knowledge of those events.
Okay.
Now, the vice principal tells the police officers, as Justice Link just mentioned, in sort of a nervous way, I know he has something on him. We can sort of tell from this record that she probably didn't have any basis for that. She didn't really have any personal knowledge that would allow for that, and it was probably just intuitive. But she is somebody who, when you look at Aguilar and Spinelli, can obviously reasonably be credited by the police. Can that factor in to the calculus on whether or not there's grounds for a pat frisk, that comment by the vice principal to the police officer?
Well, I argue that the principal failed to provide any other further basis for that opinion. He merely left it as, I think that he has something on him. So he provided no specific basis for his hunch that Mr. Villagran had something on him.
I think you're right. I mean, I feel pretty certain you're right. But my question's a little different. When this vice principal, who the police have every reason to credit and who happens to be there, is in a very anxious way in a school saying, I think he has something on him in a very, very pronounced way, can that go into the police officer's calculus as you're trying to determine at that moment whether or not there's reasonable articulable suspicion?
I believe that it could, but I don't believe that it would add up to reasonable suspicion that there was a criminal activity or that the defendant was armed and dangerous.
Could the principal himself have searched under TLO?
Well, I don't believe TLO applies to this case because Mr. Villagran is not a student at Milton High School. He was a 19-year-old civilian who was there, but he was not a student. And nor did the principals search Mr. Villagran.
Could he have been arrested for trespass?
I don't believe so. There was no evidence presented that there was any posted signs restricting him from access to the school, nor was there any evidence that anyone told him he was forbidden to remain on campus.
So anybody can walk into a high school?
I believe so.
Is that our law?
Hmm?
That's our law, that anybody can just walk into a high school and not be a trespasser?
Well, there's no evidence of his actions prior to Sergeant Murphy's arrival, so there's no evidence that would support a theory of trespassing. At trial, the Commonwealth, there was evidence presented that the secretary allowed him into the main office of the school. He buzzed himself in.
It's a school grounds issue that's at stake, though. I mean, the issue is, I understand he was invited in, but it's something like 2:30 in the afternoon, and he's on the school grounds, and the vice principal is obviously concerned enough to find out what's going on. So is that reasonable articulable suspicion for trespass?
I don't believe so because there was no evidence presented that anyone told him he was forbidden to leave or that he was an unwanted person.
And he left when he was asked to leave.
I don't believe anyone asked him to leave. He did leave the main office on his own accord.
So, and of course, the concern, of course, is that, I guess the real question is, what do we do with the principal's articulated hunch without articulating the reasons? To what extent is that enough to justify a police officer's concern where you have a principal who spends his whole day with kids saying there's something about this kid which troubles me?
Well, in this case, I believe that because the principal only said, I think there's something going on with this kid. I know he has something on him, and provided no other basis for that opinion.
Things
that-
are happening pretty fast. What do you think the police officer should have done? Asked, why, principal, do you think that?
She could have asked that. She could have asked the defendant, Mr. Villagran, what he was doing there on campus that day. Instead, she jumped straight into pat frisking him.
Was he reaching for the backpack, though?
No, there's no evidence that he was doing anything but sitting there, sweating and shaking.
What
At
do we-
one point, he wanted to leave, didn't he?
I believe he asked if he could leave at some point after the pat frisk occurred.
Oh, it was after.
So obviously palpable in this situation is that we're talking about a school. And I'm not suggesting in the question that there's a lesser standard for constitutional justification in and of itself, but doesn't it factor in, I think this goes to Chief Justice Gans's point, doesn't it factor in that this is where they are, they're in a school, there's kids there, and the vice principal is talking about, I know there's something on him. What's the police officer to do in that situation? Because, hindsight is an exact science, but we can't look at this by hindsight.
I would argue that that simple statement enough did not provide enough to constitutionally pat frisk Mr. Villagran, regardless of if it was on a school, in a movie theater, in a convenience store, that the reasonable suspicion standard still applies, and that did not provide enough support for her pat frisk.
How about at an airport?
I don't believe so, no.
Okay, thank you.
All right, thank you.
Ms. McLaughlin, good morning.
Good morning. May it please the court, Laura McLaughlin for the Commonwealth. With me this morning is trial prosecutor David Ringus. Justice Budd, jumping into your question about what the parties agree upon, the Commonwealth does acknowledge that portions of the motion judge's findings of fact were unsupported by the record. However, the Commonwealth did omit those from their brief, and without those facts and only knowing what the officer knew at the time of the frisk, there is reasonable suspicion. Further, looking at the motion transcript, the Commonwealth would argue that in addition to the overwhelming odor of marijuana, that the officer also detected alcohol prior to beginning the pat frisk. At page 12 of the record, it states, at this point, I could not only smell the marijuana, I could smell the alcohol on him. I began to pat him down. I believe the statements of the defendant that he lied and that he was sorry that he lied occurred during the pat frisk of his person.
During it?
During,
yeah.
yes, it appears on page 12 and 13. He stated, I'm sorry, I lied, I was patting him down. So that occurred as she was patting down his person, however, not prior to pat frisking the backpack.
But does the pat frisk of the person rest on any stronger ground than the pat frisk of the backpack?
Yes, Your Honor. When the officer arrived on scene, she has the information of an unwanted party trying to enter the high school. That term, unwanted, contains a lot of information that is implicit and understood and can be reasonably inferred by unwanted. The term unwanted increases the ambiguity and increases safety concerns. The officer knows that. She's brought into the conference room where she smells an overwhelming odor of marijuana. She then makes observations of the vice principal and principal. She's had prior interactions with both these parties. It's reasonable to draw inferences on her prior interactions and prior experiences as an officer. There's also the fact that the school was alarmed enough to call the police and to require police intervention that increases the suspicions. But the principal had had the defendant empty the pockets prior to the officer arriving, and when the officer arrived, he stated that there was something wrong, something's not right with this kid.
Could you say that again? What about emptying the pockets? When did this happen?
The principal had the defendant empty his pockets.
Oh, so that was already emptied, and that was on the conference room table or something?
Yes, the officer notes that she wasn't paying attention to what was on the table, but the principal acknowledged that he had the defendant empty his pockets prior to her arrival.
And what was that the cash, the wad of cash?
Nope, the wad of cash was located in the defendant's front pocket of his hooded sweatshirt with additionally marijuana that was found as the officer conducted the pat frisk.
Okay, so do we know what the principal on?
The record's unclear of what was in the pockets.
And those would have been pants pockets or something, not the sweatshirt pockets?
Yes, and the fact that he didn't conduct any further searches and waited for the police further supports reasonable suspicion.
Can I
that-
just stop you there for a moment? So I'm looking here, it looks like after he had to empty his pockets, he asked if he could leave, and he wasn't allowed to leave. Is that your understanding as well? This is before before Sergeant Murphy got there.
I'm not aware of that fact. I would have to refresh my memory in the transcript. But knowing what the officer knew before she conducted the pat frisk, all we can look for is what she knew at the time of the pat frisk. And what she knew at that time was there was an unwanted party trying to enter the high school, that there was an overwhelming odor of marijuana, that he smelled like alcohol, and that the principal and vice principal were very concerned. They were agitated, they were rushed, they were rattled. These were behaviors that were not consistent with how they dealt with other prior serious incidences at the school. The officer, in light of all those, felt it was necessary to conduct a pat frisk. It should be noted that the officer wasn't only concerned with her safety, but the safety of the students, the safety of the faculty, and the safety of the staff of the school. So that school context has to be looked at as an added factor to the reasonable suspicion analysis here.
So the danger is we have someone who's intoxicated by either or combination of marijuana and alcohol, and they're unwanted and they're in a high school.
Correct, Your Honor.
That equals dangerousness.
Correct, Your Honor. It's an unfortunate reality that there is an actual threat of school violence and shootings in school. This court has taken judicial notice of the actual and potential violence in public schools. Further, the appellate court has discussed on numerous occasions that there's essentially a heightened sensitivity that an individual may bring guns onto school property and embark on a shooting rampage.
So do we have a different rule for schools in determining reasonable suspicion?
I wouldn't say it's a different rule. The reasonable suspicion threshold is met here. However, it is a context that can be added in as an additional factor because of the concern. There is an unwanted party here. If the defendant was a student, it could be reasonably inferred that the principal and vice principal would have conducted a search for discipline reasons. But what they have here is an unwanted party trying to enter high school. Most schools have protocols of who can come and who cannot come. That was violated here. Further,
So is the fact that there have been reported shootings at schools, does that factor into the reasonable suspicion analysis? Is that what you're saying?
I would say that in addition to the report of the unwanted party. So the report of an unwanted party would heighten the concern of an officer, as well as the unfortunate reality that there is a threat of shootings in schools. So the fact that some party was trying to enter a high school would increase suspicion that they potentially could have a weapon and could potentially be in the process of trying to commit a crime.
But he was admitted by the secretary, right?
That was not known to the officer at the time of the frisk. What the officer knew when she conducted the frisk was that there was an unwanted party. Everything that occurred prior with him entering the school and leaving the school and giving a false name was not known to the officer at the time she conducted the pat frisks. That was testified to at trial by school staff members. However, when the officer arrived on scene, all she knew was an unwanted party was trying to enter the school, coupled with her observations of the vice principal and principal, the odor of marijuana, as well as the odor of alcohol.
Is there a reasonable and articulable suspicion that you've got a minor in possession of alcohol?
The record's silent on the defendant's age. However, the record's silent whether she made any observations of if he appeared to be under the age of 21. He is 19, but I can't speak of her observations if she had that information. However, when she did conduct the pat frisk of the person, she located marijuana as well as a large sum of money. At the end of the motion hearing, the detective testifies that he finds some money in the backpack, and the total sum of money is approximately $3,000, but the record's silent on the amount found in his person and the amount found in the backpack. But there is an argument that the finding of the marijuana on his person, as well as the large sum of money on his person, may have supported probable cause that the defendant was in possession with the intent to distribute, and an alternative argument to the frisk of the backpack would be a search incident to arrest.
Right, but that means that the frisk of his person was supported by reasonable articulable suspicion.
Yes, Your Honor.
So, I mean, it seems as if you have to get past the frisk of his person in order to justify the frisk of the backpack.
Yes, Your Honor. And
And are you saying it's a different standard for frisking the person than frisking the backpack? I know that there's more information.
no, it's the same standard, Your Honor. And in addition to another factor towards the reasonable suspicion is the question that Judge Gaziano posed to counsel. There was reasonable suspicion of a trespass.
You think they had probable cause to arrest for trespass?
I do, Your Honor. Defense counsel had relied on Chapter 266, Section 120, that requires notice. However, the Commonwealth has relied on Chapter 266, Section 123, that does not require notice. So the information that there's an unwanted party who smells of liquor and smells of marijuana would support probable
So, I mean,
cause.
with regard to the trespass, all you have is the information that he was an unwanted party.
Yes, Your Honor.
That's enough to say that's probable cause of a trespass?
That they're unwanted at a school, and additionally that they smell of marijuana and that they smell of alcohol.
That wouldn't go to the trespass issue, would it?
It wouldn't, Your Honor, but that alone of an unwanted party trying to enter a school would support the probable cause for that trespass, given the statute.
Known to the police officer that he was not a student, or?
It was, Your Honor.
Or that he had no other, I suppose, business at the school?
It was, Your Honor. The officer knew that he was not a student, and further, just the term unwanted would suggest that he did not have any other business at the school. And further, the fact
Not
that,
necessarily.
well, further, the fact that the police were called,
It's not good business.
that the school staff and the principal and vice principal, their suspicions were raised to the level that they determined that they needed police intervention and that police were called.
And then everything that flows thereafter is a search incident to that arrest.
The Commonwealth would also argue that there was reasonable suspicion also to frisk the backpack. It was within the defendant's reach. It was located on the table. The officer frisked the outside of the backpack as an attempt to push it out of the defendant's reach, and that's where the firearm was ultimately recovered. So the Commonwealth would argue that there is reasonable suspicion for that firearm.
Does it matter that they asked him to come into the conference room, that he was outside and they brought him in?
Your Honor, that information was not known to the officer at the time she conducted the pat frisks. She did not know how the defendant came into the school. So looking only at what she knew, there was reasonable suspicion to conduct the pat frisks at the time she did.
Does it go to the trespass issue? I mean, at the time that he was in this conference room, he was wanted because they asked him to be there.
Your Honor, there's also an argument that at the time the defendant arrived at the school, it was, I believe, 5 to 10 minutes until the final bell was rung and school was emptying out. So the principal and vice principal had concerns for about the defendant's behavior, and at the time he was brought back into the school, he was standing out in the parking lot with hundreds of students. So if the vice principal and principal were concerned about the defendant and thought he posed safety risk, bringing him into the conference room may have been the more secure and safe decision given the amount of students that were in the parking lot surrounding him at the time.
He's still on school grounds. On his own volition, he's on school grounds.
Yes.
Even if he's not in the building?
Yes.
Yeah.
So if a kid's brother goes to the high school to wait outside and the principal declares him to be unwanted, he should be arrested he can be arrested for trespass?
Your Honor, even if there is probable cause for the trespass given the statute, it's a pretty low threshold. Whether an officer would arrest, it would probably determine on the other facts, but the Commonwealth is not just relying on that probable cause, they're relying on the fact that the officer had reasonable suspicion at the time she conducted the pat frisk of the defendant person, as well as reasonable suspicion to conduct the frisk of the backpack, which ultimately where the gun was recovered. And if I just may briefly switch to the second issue, bringing a loaded firearm into a school is a willful disturbance. Before the gun was recovered, the defendant's behavior alarmed school staff. The vice principal and principal had to abruptly end their meeting to look for the defendant. The defendant provided a false name. All those suggestions were a disruption to the school. And then finally, after the gun was located, the entire school was forced into lockdown. Faculty, staff, students were unable to leave the school to enter the school for a period of hours. The Commonwealth would argue that that was unreasonably disruptive behavior. And unless your honors have any other questions, I would rest on my brief and respectfully request you affirm the defendant's convictions.
Can I ask, would it still be a disturbance if the search was unlawful? I mean, if he had the gun in his bag and was minding his own business with it?
Your Honor, the Commonwealth would suggest that the defendant's behaviors before the firearm were recovered were unreasonably disruptive. By going into the school, by providing a false name, he said he was a student and then asked to use the bathroom and then provided a false name and then left, and that alarmed the school staff enough to contact the vice principal and principal, and that interrupted their meeting. So that alarming behavior of the defendant would be an unlawful disturbance even before the firearm was recovered. So,
All right, thank you.
thank you very much.